Can anyone out there hear me?
Mr. Baldori, I heard you. I just think the court's muted at the moment, so that when they get to us, I think you're good.
All right, Mr. Smith, let's start with, I think it's Domingo Gonzalez is the first case. Does that sound right?
Yeah, it's actually both defendants were served, Gonzalez and also Saldala, Moro.
Moro Salada. Yeah.
Court file should
I
have
think we have
on both.
do we have an interpreter for that case? All right. And we don't have either Domingo Gonzalez, I don't see, or Moro Salada here.
No, Mr. Salata is here, Judge.
Mr.
He's in the
Sal-
courtroom.
You use Mr. Salada? All right. So Mr. Smith, did you want to meet with Mr. Salada? We have an interpreter here also. That looks like a discovery case. I don't know if you've so we'll set it for discovery. Let me swear the interpreter in and we'll call that case.
Thank you.
All right, so Mr. Salada, you can come up here with the interpreter. And then, ma'am, again, I've done this before. Please state your first name and your last name for the record.
Susana Villarreal, SUSANA,
All right, please raise your right hand. Do you solemnly swear or affirm that you will truly, accurately, and impartially interpret in the matter now before the court and not divulge confidential communications, so be God under the penalty of perjury?
I do.
All right, thank you. All right, so we're on the record in docket 1703271. That is Lafque versus Domingo Gonzalez and Moro Salada. Will the parties please introduce themselves for the record? Mr. Smith.
For plaintiff Lafque, Tim Smith, P48259.
And sir, you are Moro Salada?
Yes.
All right. And Domingo Gonzalez is not with you.
No. I don't know anything about him.
All right, thank you. All right, this is time set for a discovery hearing. Mr. Smith, how would you like to proceed? As you know, usually I swear them in and then have you meet on an iPad with them. We have an interpreter here and you can go through your discovery request. Is that the same? Is that how you'd like to proceed?
Yes, Your Honor. Thank you.
All right. Okay, so sir, I'm going to swear you in and then place you on an iPad with the interpreter, and then have you talk to counsel. from LAFCU. And if you have any questions from, that would be the time, but I'm going to swear you in because they're going to want certain documents as part of the discovery hearing. All right, please raise your right hand. The other right hand. Do you solemnly swear or affirm? Tell the truth, the whole truth, and nothing but the truth? Under penalty of perjury. All right. All right. So I'm going to have you follow my court officer, and she'll place you on an iPad, and then we'll come back and put it on the record from there. All right. So, Mr. Smith, I'm going to place you in a breakout room. And then the iPad's already in there. So I'm going to put you in room 1, and then we'll come back and put it on the record.
All right, thank you, Josh.
You're welcome.
Bill. They said footwork takes months to get back. Boy, were they wrong. I did this drill. It went right. 10 minutes a day. See where you're at after. I mean, my God, this drill.
The carbon steel griddle. This is a very popular one from us. It can be used on your stovetop for things like making pancakes or snack.
All right. Jeremy Chisholm from Orbit Leasing. All right. And you're waiting for Dondre Taylor?
I've got Nikki Howard listed, Your Honor. I wonder.
Oh, yeah. Yeah, that's I misread the docket. So that's Nikki Howard. Is Nikki Howard in the? You can come up here, ma'am. You can have a seat. All right, so we're on the record in docket 2408471. That's Orbit Leasing versus Nikki Howard. Appearances for the record, Mr. Chisholm.
Good morning, Your Honor. Jeremy Chisholm, it's P74670. I'm the attorney of record for the plaintiff.
All right, ma'am, you are Nikki Howard, is that correct? Is that a yes, ma'am?
Correct.
Thank you. All right, this is the time set for a motion for summary disposition. And I'm assuming it was filed by yourself, Mr. Chisholm?
Judge, yeah, it was the plaintiff's motion for summary disposition based on MCR 2.116C 910. And I guess we probably, I think it threw in I1 as well, but C9 and C10 primarily here.
All right. And Ms. Chisholm, you've had the opportunity to see that motion? Okay. You tell me, did you get the motion in advance?
I believe so. What was on it?
It's a motion for dismissal. It's a motion for summary dismissal to legally set for legal purposes to say Mr. Chisholm has proved his case by legal authority. Would you like the opportunity to speak with Mr. Chisholm?
I mean, no, but the only paperwork I received is the court paperwork to come here today.
So you have not received the motion.
No.
Mr. Chisholm?
Not a
Judge,
motion
there
for
is a proof of service in here on July 28th. Wendy Colson did mail it to an address at 6080 Marsh Road, Apartment 2 in Hazlet.
Is that the correct mailing address?
I did contact the courts because something did come in the mail, but they didn't send me that. They sent me the paperwork for today. Because my mail lady decided that she was going to take it upon herself to say that I moved out because my mother moved in with me and put her name on the mailbox. So she stopped delivering my mail. But I did contact the courts and they emailed me a document and it was just to show up here today.
Mr. Chisholm, I don't know. The indication is that Ms. Howard is indicating she did not receive the motion. I don't know. I don't know if we have proof of service for the motion. But it'd be hard to respond to a motion that you haven't seen. Mr. Chisholm, do you want the opportunity to speak with Ms. Howard concerning this motion to explain to her, and then either we can reset the motion or take a look at the proof of service. But there's an indication today that she did not receive the motion.
Judge, I'm happy to speak with her about that, and I don't know if it may be beneficial if at that time, if she's willing, I'm happy to email this over to her and we can reset it for. I know that there's a trial date on right now towards the end of September. I don't know if we want to maybe we can reset the motion to that trial date and then reset the trial date if necessary out farther. Given if she hasn't seen it, I'm more than happy to provide it for her so that opportunity.
Let's do this. Do we have the second iPad available?
Just in the office.
Just the office, okay. Let me put you in a room with Mr. Chisholm, and he can explain to you the nature of the motion. And
this is their lawyer, though, right?
Correct.
So I don't really feel comfortable talking.
Well, that's fine, but then I'm just going to reset it since you don't have the opportunity to indicate. He's going to tell you why we're resetting it, and it's because you're indicating you haven't got the motion today.
Okay.
That's really the nature of the conversation.
I mean, I completely understand. If that's all he's going to tell me, I understand that.
Do you have an email address that'd be a good address for Mr. Chisholm to send that motion to?
Yes.
Why don't you provide that to my court officer? She'll take down the email address and then we'll reset it. I'd hate to keep this, Mr. Chisholm, waiting any further. We can probably set it before the trial date.
Okay, that's fine, Judge.
Yeah, seeking legal representation too.
Okay, so for the record, you've indicated that you're seeking legal representation. What's the name of the lawyer?
I'm in between two different ones right now. I'm trying to come up with the money for one of them. So,
what are their names, ma'am?
the one. I know,
It's hard to pay them if you don't know their name.
like I said, I'm in between the two, so I'm trying to see which one I can afford.
Okay, what are the names of the two attorneys you're looking at?
I think it's like the Goldman Law Firm and something else.
Mr. Chisholm, it appears that Miss Howard is looking at the Goldman Law Firm,
The Goldman and Associates Law Firm.
and you've not received an appearance on her behalf, is that correct,
That
Mr.
is
Chisholm?
correct.
All right. All right, so let's do this. Let's reset this. You can get the email from my court officer. She'll, I think you can put it in chat to Mr. Chisholm. Is that a fair statement, Ms. Slaviak?
Yeah, I will chat it. Sorry, Jeff,
All
I
right.
didn't realize you were talking. I
No.
thought you were talking to him. Yeah, let him know. I will chat it to him.
So Mr. Chisholm, we're gonna give you the email address so you can send it. You'll get it from my court officer.
All right, thank you.
And then we're gonna set it pre the trial date, just to have that trial date as a backup. I'd say about 3 weeks. Well, when's the trial date on this one?
September 26th.
All right. Well, that's right. So be right at,
It's September, what was it?
the trial date set for September 26th.
I have September 25th.
Maybe.
A month from
You're
today.
right. I'm sorry. I misspoke. It's
I was like, wait a second, is this a?
It's the 25th.
Yeah.
And so are we looking before that or?
September 11th.
All right. All right, so Mr. Chisholm, we're gonna adjourn this for the plaintiff has indicated that they don't have the motion. They've provided an email address. And we'll come back for the motion on
September 11th at 2:30.
September 11th at 2:30. That'll be before the trial date that's set. I think a pretrial's already been done on this case. Is that a fair statement, Mr. Chisholm?
Yes, Your Honor, I believe so. We
All right,
had
Ms.
a
Howard,
pretrial
that-
order in place.
Yeah, there's a pretrial order. I have a pretrial order in place, indicating just a calendar of events of when we're going forward.
Okay, and then for September 11th, can I appear on Zoom?
You can,
So I could have came to Zoom on this one too?
you can.
They told me I had to appear in person.
But,
That's what the paperwork said.
I don't know. You can appear via Zoom.
Zoom? Okay,
Yeah, that
perfect.
you,
I will be out of town that week.
as long as you're here via Zoom.
Okay.
And you have access to the email address for the motion.
Yes, correct.
Is that a fair statement, Mr. Chisholm?
Sounds good to me, Judge. Judge, I am sorry,
All right.
I missed, I think I mistyped. Did you say it was September 11th at 2 p.m.?
2:30.
2:30.
2:30. Okay, thank you.
So we'll see at September 11th at 2:30. We'll provide Mr. Chisholm the email address that you provided to the court so that you can get the motion and everything and go from there. All right, ma'am?
Judge, can you have him confirm that he got my message?
Mr. Chisholm, did you get the message from Ms.
I did,
Slaviak?
I did, and I'm already in the process of getting that motion
Perfect.
forwarded to Ms. Howard right
All
now.
right. So your email address has been given to Mr. Chisholm so that he can provide with paperwork. All right. All right, I'll see everybody on September 11th at 2:30. Thank you for your appearance today.
Thank you.
Thank you, Your Honor.
Thank you. Is there a representative of JP Morgan Chase Bank? Okay. And is Mr. Brito here?
I have not had anyone check in.
Let's go ahead and call that case. We can call that case. So, Mr. Net, I'm gonna have you step out so we can hear if you want to talk to Mr. Staples, just because we're gonna go on the record. All right, ma'am. Are you Miss Royce?
No, I'm Carol Grabala, attorney. I can give that to you. But I'm here from Mr. Royce's office.
All right, what's your name, ma'am?
Carol, last name is Grumbala, Grombala. My P number is 41597. Appearing for JP Morgan Chase.
All right. So we're on the record in docket 24-08509. That is JP Morgan Chase Bank versus Austin Brito. Appearances for the record, Ms. Grimbal.
Yes, good morning, Your Honor. Carol Grumbala, P number 41597 on behalf of JP Morgan Chase.
All right. And is there an Austin Brito? I do not see an Austin Brito in the Zoom courtroom. There's nobody answering to that name in the hallway or the physical courtroom. This was set for 8:30. It is now 9:10. So it would appear that Austin Brito, D1, has failed to appear for the pretrial. This is a pretrial. Is that correct,
It is
ma'am?
correct, Your Honor.
Eight 8:30. Now 9:10. Ms. Grimbal, how would you like to proceed?
Your Honor, based on not appearing today, I would like to submit a default under the 7-day. That is all right, Your Honor.
The default for non-appearance to be submitted by the plaintiff. I will orally indicate that Mr. Brito is not here, and then I'll wait the order to sign.
Thank you, Your Honor.
Anything else for the record in 24-08509, Ms. Grimbal?
No, Your Honor.
You're all
thank you.
set. Thank you.
Have a good day.
You too. All right, Mr. Baldori and Mr. Akanicki, we can call. I have you set for a hearing and a pretrial on that Trinity Enterprise. So we can call that case. Mr. Baldori, you ready to proceed on that case? You have to unmute.
Oh, how about that? Is that working?
Yeah, it is working, Mr. Baldori. How are you?
I'm subbing for my son who had a conflict, but I'm here.
Okay, good. It's good to see you. Haven't seen you in years.
I know. I'm going to stop out later today in person.
All right. All right. So we're on the record in docket 25-03076. That is Trinity Enterprise versus Best Choice Home, Christian Wobu. And then we have a pretrial set for the same parties. Appearances for the record, Mr. Baldori.
Robert Baldori for the plaintiff.
Mr. Akanicki.
Good morning, Your Honor. Robert Akanicki for the defendants.
This is the time set. I have a hearing and a pretrial set in this matter. Mr. Baldori, how are we proceeding today? Or would you like to defer to Mr. Akanicki?
I think we have a settlement, but I will refer to Mr. Akanicki to.
Mr. Akanicki.
Yes, Your Honor, we have a settlement on this matter in full. We settled it very late last week, so me and the other Mr. Baldori weren't able to put a settlement agreement together. But if the court wants to maybe set like a control date so they make sure they get the dismissal, I don't think we'll need any more hearings on this.
Okay, I was at conference last week, so if it was signed, I'm not sure who signed it or, but I do have an indication that, is that a fair statement, Mr. Baldori, that this settlement has been agreed to, and we're just setting it for control date today, just to make sure it's signed?
That's my understanding. Yes, Your Honor.
All right. Okay, so I'll await the order to follow, if not already here, and we'll set a control date for how far out do you think, Mr. Baldori or Akinicki?
Well, Your Honor, just to be clear, we have a settlement in principle.
It's hard, yeah.
We just didn't sign it.
This is really belt and suspenders kind of territory, I know.
Yeah, we didn't sign anything yet, but we have agreed to everything all clients have. So I think if we set it out for like 30 days is more than enough.
Is that a fair statement, Mr. Baldori?
Yes, it is.
All right. All right, we'll set it 30 days out or in that vicinity. We get a date and then we'll just await the order to present itself. If it hasn't already, maybe already signed, I don't know.
Not quite yet. Hasn't been submitted yet.
Okay.
September 22nd.
All right, let's set it. And then you can tell me if we still need the date. But we've set it for September 22nd at 8:30.
Sounds good. Thank you, Your Honor.
Thank you. Yes.
All right. So we'll set that for control date and I'll await the order to follow. Anything else for the record in docket 2503076, Mr. Baldori?
No, sir.
It's good to see you, Mr. Baldori.
Hey, my kids got me working. I'll be out there later today on another matter.
All right. Sounds good. Anything else, Mr. Akinicki?
No, Your Honor. Thank you.
All right. Thank you. Thank you both for your appearance today.
Thank you.
All right, Mr. Smith, we'll call your case with the interpreter and Mr. Salata.
Thank you, Judge.
All right, so we're back on the record in 1703271. That is Lafke versus Moro Salata. And Mr. Smith, you had the opportunity to speak with Mr. Salata in a breakout room?
I did, Your Honor. We completed the Q&A part of the examination. There are documents, though, that are responsive to the court's subpoena, most importantly related to a banking relationship he has. I'm going to get in writing to Mr. Slater, and I explained this to him via the interpreter, that I'm going to get in writing to him, reminding him what needs to be sent and exactly where to send it. We'll give him 30 days to get that here. He indicated that that was enough time. He thought he could pull everything together. If we don't see the documents, we'll simply file a motion to show cause, and I explained that to Mr. Slater.
All right. So you don't, Should we set this for control date, or you'll just wait for the documents and you can show cause?
We don't need we don't need a control date. I anticipate receiving the documents. He seems he understands the situation and seems very motivated to get the documents to us that the court ordered.
All right, Mr. Salata, do you have any questions of me?
No, just the documents that I need.
All right, that's, Mr. Smith's just looking for the information. It'll be provided within 30 days. Anything else for the record in docket 173271, Mr. Smith?
Not as it relates to Salata, but we do have the matter of the non-appearance of the co-defendant Gonzalez.
All right, and how would you want to proceed in regards to Mr. Gonzalez, Mr. Smith?
The court
This
file
was
should
set for
reflect
8:30.
personal service on June 17th. He's failed to appear today. We'll file a motion to show cause with 9-day mailing to the same address where service was personally effectuated on the underlying subpoena.
All right, this was scheduled for 8:30. It's now 9:19. And it would appear that D1 has failed to appear. And then I'll await the order to follow concerning show cause on Mr. Gonzalez. Is that a fair statement, Mr. Smith?
It is, Judge. Thank you.
Anything else on 1703-271, Mr. Smith?
Nothing for plaintiff, Your Honor. Thank you.
All right, you should be all set, sir. You should get the paperwork in the mail concerning what documentation is to be received by Mr. Smith. And ma'am, thank you for your assistance today.
Thank you. Thank you.
Thank you,
You're all
Madam
set,
Interpreter. Thank
Mr.
you, Judge.
Smith. I got you on another case,
Yes.
on Dondre Taylor.
We have an
Yes,
interpreter.
yes.
on another case, I
Oh,
believe, And we have Mr. Smith on another case, but I don't think they're the same thing.
Okay, all right. What's your case, ma'am?
My case is, Roberto Campos.
All right, that's at 10 o'clock. All right.
I think DeAndre Taylor was an 8:30 as well, Your Honor.
Yeah, I'm gonna call that right now. So we're on the record in docket 1800470. That is Lafque versus Dondre Taylor. Appearances for the record, Mr. Smith.
For plaintiff Lafque, Tim Smith, P48259.
Okay, is there a Dondre Taylor in the physical courtroom? I do not see a Dondre Taylor in the regular courtroom, in the Zoom courtroom, and nobody's answering by that name in the hallway. Mr. Smith, it appears that this was set for 8:30. It is now 9:22, and Dondre Taylor has failed to appear for the discovery hearing. How would you like to proceed, Mr. Smith?
The court file reflects personal service on June 19th. In light of the defendant's failure to appear today, we'd like to file a motion to show cause, serve it by 9-day mailing to the same address at which the underlying subpoena was personally served.
All right. So I'll await the show cause order to be filed and sign it. I'm indicating that that verbally it's granted, but I'll have to sign the order and then we'll go from the show cause. And that you indicated that's 9 days. Is that correct?
Yes, Your Honor. We'll prepare and submit.
All right. Anything else for the record in 1800470, Mr. Smith?
Nothing, Your Honor. Thank you.
All right. And then I have a couple of your cases. Is that also at 10?
Yeah, I think Van Noller's at 10 o'clock.
All right.
I'll zoom back
All
in.
right. Well, all right. We'll see you then.
Thanks, Judge.
Thank you. Should. All right, so we're on the record in 25-00852. That is City of Lansing versus Myron Gilmore. Appearances for the record, Mr. Staples.
Matt Staples on behalf of the city of Lansing.
Mr. Devon.
George Annette, APD on behalf of my client is not here today, Your Honor.
This was set for 9 o'clock. It is now 9:42. Mr. Gilmore does not appear to be on the Zoom courtroom. There's nobody in the physical courtroom and nobody answered by that name in the hallway. It would appear that the defendants failed to appear for the pretrial today. Mr. Staples, how would you like to proceed?
Your Honor, I do not see any previous failures to appear for Mr. Gilmore on this file. I believe, based on previous experience, Mr. Gilmore may be an individual experiencing homelessness, so the city would have no problem with a 48-hour hold on this.
Is that a fair statement, Mr. Annette?
Yes, Your Honor. Is today set for pretrial or from pretrial?
I have pretrial on this case.
Pretrial is what's on the docket.
Okay. Your
But then
Honor,
I have final pretrial in my notes, so I don't know.
okay. Yeah, I did try to reach out. I did speak with the mother sometime last week. I got a voicemail back with him and his mother in the background. Tried to call back. I called back. She said that he wasn't with her at the moment. He'd call me back, and that was sometime maybe Friday or Saturday or Friday or Saturday.
All right, for the non-appearance of the for the pretrial or final pretrial, however we want to call this, it appears that we did have this date, time, and set, and so he knew of this time set based on some of council's representations. I do not have a previous bench warrant on this file, so we'll issue a bench warrant with a 48-hour hold. Anything else for the record in 25-00852, Mr. Staples?
No, Your Honor.
Mr. Ned.
No, Your Honor.
Thank you. And then we're ready on Robinson, you said?
Yes, Your Honor.
Two tickets in a file, I think. All right, so we're on the record in docket 25-01495, 25L2944372, and 25L2944373. That is the City of Lansing versus, I have it as Devontae Robinson Johnson.
That's correct.
All right. Appearances for the record, Mr. Staples.
Matt Staples on behalf of the city of Lansing.
Mr. Ned.
Thank you, Your Honor. George Annette, APD on behalf of my client is appearing via Zoom.
And sir, you are Devontae Robinson Johnson, is that correct?
Yes, sir.
All right, thank you. This is a time set for a pretrial in the matter. Mr. Staples, how are we proceeding?
Your Honor, there is no offer on this file, so I believe at this point we'd be setting for jury trial.
Thank you, Your Honor. And because there's an offer, we're going forward with jury trial this time.
So a set for jury trial. On the, and we'll just put it all together. We'll put them all on the same date. Because two of them were misdemeanors. Let's see. Yeah,
I believe there's one misdemeanor and two civil infractions.
two civil infractions. All right. A date for jury trial.
October 27th at 8:15.
October 27th at 8:15. So we've set a jury trial for October 27th at 8:15 for the fail to stop. The fail to yield was a civil infraction. It'll be set for that same date. For October 27th at 8:15. And then the fail to stop within an assured clear distance will also be set for formal hearing on that October 27th date at 8:15, since I'm assuming the witnesses will all be the same. All right, anything else for the record in 25-01495, Mr. Staples, or the accompanying tickets?
No, Your Honor.
Mr. Ned.
No, Your Honor.
All right, Mr. Robinson, you should be all set. The jury trial and formal hearings are set for October 27th at 8:15. All right, sir?
All right, thank you.
You're welcome.
One more question.
Mr. Devontae, I'll give you a call later today.
Okay, all right.
All right. All right, Ms. Hayes, you're here for your 10 o'clock pretrial? Ms. Hayes Lawson? She doesn't have audio.
Is my Wi-Fi on? Yeah. Oh no. There it is. Come on, come on.
Do they have their mic turned off?
All right,
No.
so Nancy Hayes Lawson, you're here for your 10 o'clock?
Yes.
All right, stand by. We'll call that case in about 15 minutes, all right?
Okay, thank you.
You're welcome.
Okay, you got it. Now listen. When you see that fucking lawyer, you tell them that when they ask you, that's to you say not to you guys, that's the original credit. You are, you bought that case, you bought that. The truth. I know you.
Listen. They can hear what you're saying.
Yeah,
I put the phone down. You gotta stop that, okay? You're gonna get me in contempt of court.
You know what to do?
Yes, go.
25.
I'm still waiting.
Say so.
Nothing. I'm waiting. I'm waiting.
They didn't come on there for you?
No.
So sick.
I know.
You know. Wait. Wait, it's not that. Your case will be dismissed.
Hello? Hello?
Good morning, ma'am.
Yeah, we'll call your case in just a second, all right?
Okay. Okay.
Thank you. You're. So you're Nancy Hayes Lawson, you're here for your 10 o'clock?
Yeah.
All right, and Veronica Parker.
Put that right there.
Ms. Parker, what case are you here on?
I'm not. I'm just with him, with Keenan Sanders.
Sanders. All right. All right, we have Sanders here. So you're in the right courtroom. That's on our docket. Tyler Van. Mr. Van Noller, you're here for your 10 o'clock?
Yeah.
All right. All right, Ms. Richter, you're here for your 10 o'clock and you're here for portfolio recovery. Is that correct?
Yes, good morning, Your Honor. That's correct.
Mr. Smith, you're here for Lansing Automakers and LAFQ.
Correct, on the Van Oler matter.
Okay. On the iPhone 3, would you please identify yourself? On the iPhone 3?
Keenan Sanders.
Oh, no, I got Miss Parker. Oh, you're Sanders, okay. All right. And Keenan Sanders, you're here for your 10 o'clock?
Yes,
Is
sir.
that correct?
Yes,
All right.
sir.
All right, stand by. You're in the right place. And Mr. Cates, what case are you here on? 1-7. You're here on Enterprise. Mr. Cates, you're here for Enterprise Leasing. All right, so Mr. Smith, we can call your first case. Six, seven, this one, three, base. There it is, 1, 3, 5. All right, so we're on the record in docket 1302023. That's Lansing Automakers Federal Credit Union versus Tyler Van Oler. Appearances for the record, Mr. Smith.
For plaintiff LAFQ, Tim Smith, P48259.
And sir, you are Tyler Van Oler, is that correct?
Yeah.
Thank you. This is time set for discovery hearing. I have only Mr. Van Oler on my documents. Is that all you have, Mr. Smith?
Correct. We're in the midst of the discovery process with the co-defendant, Lonnie Van Oler, but today is related solely to Tyler Van Oler.
All right. And Mr. Van Oler, what this usually is a discovery hearing in which I swear you in, then I'll place you and Mr. Smith in a breakout room, and Mr. Smith can describe you some of the documents he might need from you. All right, sir?
Okay.
All right. So I'm going to indicate that all parties appeared. And Mr. Smith, would that be a fair statement? I can swear Mr. Van Oler in and then place you in a breakout room?
Correct. We'll conduct the creditor exam in the breakout room. There's probably going to be some documents responsive to the court subpoena, but we'll give Mr. Van Oler time to get those to us.
All right. Mr. Van Oler, I'm going to raise your right hand as best you can. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yep.
All right. Let me add that. No. All right. So, Mr. Van Oler, you're going to get a prompt to go to room 1 along with Mr. Smith. And then once you're done in the room, we'll bring you back and we'll put it on the record. Okay.
Okay.
All right, Mr. Smith, you'll also get a prompt to go to room 1.
Thank you, Judge.
You're welcome. Seven, I think that's a file. 7. All right, Ms. Richter, we're ready to call. Well, let's go on, Mr. Case, are you here on 1704234? Mr. Cates. You have to unmute. You're muted up. All right, Ms. Richter, we're ready to go on your pretrial. So we're on the record in 25-04442. That is portfolio recovery versus Nancy Hayes.
Yes, good morning, Your Honor. For the record, Christine Richter, P61525, appearing for plaintiff.
All right. And ma'am, you are Nancy Hayes, is that correct?
Yes, sir.
Nancy Hayes Lawson?
Yes.
All right, thank you. This is the time set for pretrial discovery. Making sure I check all the boxes on this computer. Ms. Richter, I don't know if you've had the opportunity to speak with Ms. Hayes, but so I'll leave you the options. This is set for pretrial today. You can have the opportunity to speak with Ms. Lawson if that would help. And we can fill out a pretrial form indicating we just set a pretrial schedule, a scheduling, and what motions we usually keep motions for summary disposition. And we set a discovery matter for 90 days out. We can fill out that paperwork, or you can meet with Ms. Hayes. It's entirely up to you. Ms. Richter, how would you like to proceed?
Your Honor, as I understand, my client is looking at Ms. Hayes' situation for a potential hardship. I do know that's going to take a little bit of time on my clients. And so perhaps we can just go ahead with the scheduling order and set those dates, and we can hopefully get a final decision on whether that hardship will be granted. And I would just say to Ms. Hayes, if you do get any requests for information from my client, please respond to it so that they can fully review your situation.
Thank you.
All right, Ms. Richter, I will also leave up to you. We're going to print out that pretrial. I could also adjourn this matter for 30 days to see if you want to build in some extra time. It's entirely up to you.
You know what? I think if we just go ahead and set the 90 days, we should have a definitive answer by then.
All right.
And then.
So I'm in possession of the pretrial statement on docket 25-004442. Ms. Richter, would you consider this? The pretrial was held on today's date. Appearing for plaintiff was Christina Richter, and defendant was in pro per. What that means is you're appearing for yourself, Ms. Hayes Lawson. Is that a fair statement?
Yes, sir.
Yeah.
All right. I have this, we've termed this, and this is kind of boilerplate, as a breach of contract issue. Would that be a fair assessment, Ms. Richter?
Yes, Your Honor.
Right. Do you anticipate any additional pleadings at this time other than the motion for summary disposition at this time, Ms. Richter?
No, Your Honor.
Ms. Hayes Lawson, I would assume that you don't have any additional pleadings that you'd be responsible for filing?
No, sir.
All right. I've held back on a motion for summary disposition and response, as we always do in these matters. I'm going to indicate that there's no consolidation in the case, and any admissions of facts or exhibits are not applicable because the discovery time is not up. We've set a cutoff date for discovery for November 24th of this year, 2025. Expert witnesses, damages, and joinder of claims are not applicable because we've not done a full discovery for this time period. Ms. Richter, did you pay for a jury trial fee in this matter? Or is this still a bench trial?
Your Honor, it says bench trial is my understanding.
Okay. And Ms. Hayes Lawson, this is still a bench trial to the best of your understanding?
I don't understand what
you not paid a check for a jury trial in a civil case. You've just kept it as a judge trial in front of myself.
Okay.
Yeah. That's just to make sure that that you haven't. We placed that in here to make sure to remind you that you have to pay a check for a jury trial in a civil case. That hasn't been paid in this matter, and it's a part of the pretrial statement.
Okay, how much is that?
I don't know. I have no idea. But you won't have to pay it. The plaintiff usually is responsible for whether they want a jury trial or bench trial. And Ms. Richter's indicated that the bench trial is fine at this time.
That's correct.
Okay.
All right. I'm going to say possibilities of settlement. Negotiations are continuing by the party. And then unless I hear differently from the parties, this has not been set for evaluation or mediation. Is that correct, Ms. Richter?
Yes, Your Honor.
All right. All right. So the most important thing of the pretrial discovery is the date of the discovery cutoff is November 24th. And then we've left a motion for summary disposition and response to be filed near that date or after that date, depending on the parties, what the parties want. Ms. Richter, do I have your permission to sign this via Zoom?
Yes, Your Honor.
I'm going to indicate that Ms. Hayes Lawson is pro per. Do you have any questions concerning the pretrial statement, Ms. Hayes Lawson?
No.
All right. Do I have your permission to sign this via Zoom? And this is also being recorded.
Yes.
Okay. I'll sign this as a sitting judge for August 25th. And then we'll provide a signed copy to each one of the litigants for your own records. All right, Ms. Richter?
Yes, thank you, Your Honor.
All right. Ms. Hayes Lawson, do you have any questions of me?
Yes, when I go again, I guess I don't understand a lot of this, but I wanted to know if it would be via Zoom again, because my legs are really bad and I can't really walk that good.
Yeah, I think that's the plan is to do this via Zoom. If we're is that a correct statement, Ms. Richter?
Yes, Your Honor.
All right, and there's also there's the understanding. My understanding is that is being part of the negotiations, maybe a hardship issue, and so we're looking into that. So this is just setting a schedule, setting a schedule for timing purposes. Is that your understanding, Ms. Richter?
Yes, Your Honor.
All right. All right. You will get the pretrial statement mailed to you in the mail. Any other questions, Ms. Hayes Lawson?
No.
You should be all set today. Thank you for your appearance today. Thank you, Ms. Richter.
Thank you, Your Honor. Thank you, Ms. Hayes.
Thank you.
Get off. Mhm.
And then Mr. Cates, are you ready on the portfolio? On the enterprise leasing?
Yes, Your Honor.
Concerning this matter, have you had the opportunity to speak with Mr. Sanders before the motion? Would you like that opportunity?
If he's here, I haven't seen
I
him.
think he is. I think Mr.
I'm here.
Sanders is with Mr. So prior, this was a motion brought on by Mr. Sanders, I believe.
Yep.
All
Yes,
right,
sir.
Mr. Sanders, would you want the opportunity to speak with the legal representative of Enterprise Leasing before we go forward with the motion?
It doesn't matter to me, Your Honor.
All right, let me place you in a breakout room. You're here on two devices, Mr. Sanders. You're here on the iPhone 3. I'm going to place both devices in the room, in the breakout room. We'll come back and put it on the record, and we'll go forward with the motion if the parties still want to go forward with the motion. All right?
Yes, sir.
All right. So, Mr. Cates, I'm going to put you get a prompt to go to room 2. And then I'm going to place the iPhone 3 and Miss Parker in room 2. All right. So you'll get a there. Perfect. And then Mr. Smith, should we bring Mr. Van Oler back?
Yeah, we're having some trouble getting straight answers. Need a little help from the court, Your Honor.
All right.
Just the case number.
All right, Mr. Smith, I'm having some trouble bringing Mr. Van Oler back. So give me a minute. All right, so Mr. Smith, we're gonna eventually close all the rooms if we can't bring him over. I just want to make, we have another room 2. We have somebody in room 2. I want him to come back before we do that because I can't bring him over for whatever reason.
Okay, I'll sit tight.
And then, did you want to go on is Mr. Campos here?
Yes, we're here.
All right. Did you want to go on Campos?
Do we have, I didn't see that on my.
Alberto Campos, and we have a translator.
Okay, how do you spell the last name, Judge?
Campos.
And is that, you said it was, is it Manuel?
It's Roberto Galvez Campos.
Got it. Let's see what we got here. Yeah, we didn't get any of the documents on this one. I can take that one now while we're figuring out Mr.
That's probably a good idea. All right, so I'm gonna have Mr. Campos and the translator. I'll swear the translator in. All right. All right, ma'am, I'm gonna have you spell and state your first name and last name for the record.
Susana Villarreal, Susana Villarreal.
Please raise your right hand, ma'am. Do you solemnly swear or affirm that you will truly, accurately, and partially interpret in the matter now before the court and not divulge confidential communications? So if you got it under the penalty of perjury. You just let me go. You let me know if I'm getting a little fast.
Okay.
All right. All right, so we're on the record in docket 1601-363. That is LAFQ versus Roberto Campos. Appearances for the record, Mr. Smith.
For plaintiff LAFQ, Tim Smith, P48259.
And sir, you are Roberto Campos?
Yeah.
All right, thank you. This is time set for discovery. Discovery. I think we needed a Spanish interpreter last time on August 5th. Is that correct?
Yes, Your Honor.
So we met, and then, so we have the interpreter here. Did you want to meet with both of them? Well,
if I could,
I'm gonna have, yeah, we'll probably put you on a breakout room in a minute. We just have to make sure that Mr. Neps is able, so we'll call Mr. Ned's case. Is that on Hall?
Yes.
Yeah, so we'll call just wait back there, and that'll let him give him time to take the man into back to the jail, and then come back and put you on an iPad. All right. So we'll adjourn for about 10 minutes. All right, so Mr. Smith, we're going to adjourn for about 10 minutes just to get, because we have a case of pretrial before in which we have to put a person down to the jail. We'll seek assistance on it. So I'll call that case in about 10 minutes.
Okay, I got to go jump over to Judge Clarizio for a quick sec, and I'll be straight back. Okay, 10 minutes.
All right. We know where to find you.
You bet. Thanks, Judge.
These are all convictions.
All right, so Mr. Smith is in another breakout room with an interpreter. So stand by, Mr. Van Oler. We'll go back on the record in your case. And then on Mr. Cates, were you ready to go on your file?
Yes.
Enterprise leasing. Okay. All right, so we're on the record in docket 1704234. Appearances for the record, Mr. Cates.
Good morning, Your Honor. Andrew Cates, P78292 for Enterprise Rental.
And sir, you are Keenan Sanders, is that correct?
Yes, sir, it is.
All right, thank you. This is the time set for motion today. Mr. Cates, you've had the opportunity to speak with Mr. Sanders in a breakout room. What if anything came from that, or how are we proceeding today? This is on Mr. Sanders' motion.
Your Honor, there is no resolution. We need to proceed with the motion.
All right, Mr. Sanders, I have a motion that you filed. I'm going to read that into the record, and then you can supplement it in any way, and then I'll hear from Mr. Cates. All right?
Yes, sir.
This is based on a motion that was brought from Mr. Sanders on August 6, 2025. It indicates Keenan Sanders is written this because the money they took out of Comerica Bank wasn't my money. It is my dad's money that he worked for and saved up, and the proof is in the Comerica statements, all the transactions from day one. Is that the nature of your motion, Mr. Sanders?
Yes, it is.
All right. Did you want to supplement that motion with any, did you want to make any other arguments?
Well, I just wanted the court to know that in May, I moved down to Detroit to help my dad move up here to Lansing. I had no bank account, no money, no nothing. I went down there to get with him and help him with his everyday affairs. Come to find out, the insurance and several people had been getting over on him as far as his finances. He retired from GM, sir, did 30 years.
All right.
That money was his money. I just put my name on the account to move him up here to Detroit, not thinking about anything that I owe.
But Mr. Sanders, you would agree that your name was on that account?
Yes, it was.
Okay. Mr. Cates' response.
Your Honor, the defendant's name was on the account. This account, the account that we're collecting on is in the name of the defendant. There has been no proof that the funds were exempt in any way, shape, or form under state or federal law. So we ask that this objection be denied at this time.
Mr. Standards, you've indicated that the proof of your dad's account would come from Comerica Bank or your dad, I would think. Are either one of those here for this motion?
I have my Comerica paperwork right here, Your Honor.
They printed out months and months of paperwork stating that that's Earl Sanders' money, his pension and Social Security.
Were you able to share that with Mr. Cates?
He didn't give us a chance to go back to the court.
Right.
He didn't want to hear it.
Okay. Mr. Cates.
I tried to let him know that, Your Honor, that was my dad's money, not my money. I had money taken from me for taxes. I didn't put up no dispute because I knew I owed, but that was my dad's money from his retirement. And I have the proof on the Comerica bank statements and all. And before
Mr.
then,
Cates,
you'll see that I didn't have no account, sir.
So you're not disputing whether this is a valid order for garnishment?
Yes. No, he's not disputing the garnishment. He disputing that it wasn't his money.
Money. That's what I'm disputing.
Right.
Because he was garnished before through them.
Correct, but Mr. Sanders, I understand that, but your name was on the account. Is that correct?
Not even for 24 hours, sir.
All right. All right. But so, Mr. Cates, does this come out of a garnishment?
I'm sorry, I don't understand the question, Your Honor.
What's the nature of the order? There was an order that Mr. Sanders is responsible. I was just wondering if it came out of a garnishment.
Yes, this is a garnishment.
It's a garnishment for Keenan Sanders, not Earl Sanders. And we got proof.
Right. I don't see any problem with the paperwork as it appears, except that you're indicating that the money is actually, is the account in your dad's name now?
Yeah, it's always
It's
been.
always been in his name, Your Honor.
He just started having dementia, and Keenan went up there and he wanted to add his name on there because he cannot do nothing with the bank account without his name being on there, not thinking about no garnishment or anything.
Well, who's responsible for the debt to Enterprise?
Keenan
I
Sanders.
am, sir. I'm not saying I'm not responsible for my
So
garnishing.
what are we gonna what are we gonna do about the debt to
This was
Enterprise?
his-
Because it appears your name was on an account. That's the account they used for garnishment, and now you're telling me that the money they took is not your dad's, was your dad's money.
And it was, sir.
We have
Okay.
paperwork.
I got
So
paperwork from Comerica.
I'm trying to make sure they don't take your dad's money again.
That's what I'm
He
trying
ended
to
up taking his name off the account, and I added my name.
That would
The only reason my name
certainly would
wasn't on there
help.
the first time, I ended up having brain surgery.
But I can't, you're not indicating that for the time period of the actual event, how much money was taken?
19,000 or something. They wiped out his account. And I'm his guardian, Earl Sanders' guardian, and I take care of all his bills and stuff.
And Mr. Cates, your indication is that the objection was, the garnishment was correctly taken from Keenan Sanders, who's as the debt to Enterprise.
Correct.
When was the name Keenan Sanders taken off the account and Earl Sanders was placed on the account? What date was that?
No, Earl Sanders' name's always been on the account. Keenan Sanders' name was added to the account.
What date was that, ma'am?
I think the end of May, around May.
And there was a order against Keenan Sanders.
That's what I'm finding out. Yeah, it was an order against Keenan Sanders. If I knew that, I would allow him to put his name on it.
That's essentially your argument, correct, Mr. Cates?
Yes, Your Honor.
I just want to state, if you pay attention to the bank statements, if you allow us to give them to you, you'll see that Keenan have no transaction going into that bank account unless it was for his father.
Here's the problem, ma'am. It's Keenan's name is on the account.
I'm not disputing that.
I know that's the problem.
To help his
the
father.
problem is that Keenan's name is on the account, and then once he gets control of money, his debts become the bank's his debts become Earl's debts.
But how can they take Earl Sanders' money, his pension?
They didn't. They took Keenan's money.
Huh?
They took money that was in control of Keenan. Once Keenan put his name on the account.
But it wasn't.
Unless he lied when he put his name on the account.
Sir, when I put my name on the account, my father already had 20-some thousand in his account.
Yeah, that's a problem. That's a problem with the collections concerning this garnishment. Is you've made your debt his debt by placing your name on an account. Is that a fair statement, Mr. Cates?
Yes, Your Honor.
That was his pension, Your Honor, from him working 30 years at GM. He retired from GM, sir. I had no money when I moved down there in Detroit.
That he saved up.
So in essence, Mr. Sanders, what you're indicating is that you owe your father $20,000. Is that what you're indicating?
I had no clue that it would take his pension, sir. I wasn't thinking about that. I was thinking about
Well,
saving him from being in
that's,
Detroit by himself
yeah,
in a
that's,
3-story house. Like I
that's
said, I
why we're
have the
here.
proof that I had no money, sir. So
Yeah,
that's
but your
his
name
money
is on
from.
the account.
So y'all saying y'all gonna take his pension and social security that he have to live off?
Mr. Cates, I don't know what your position is to object in this matter. I know that. But it seems to me that I could adjourn this for 30 days to see what your client's position is on this. Mr. Cates.
And for the record, Your Honor, I want to pay my debt, but with my money.
I understand that.
It's not that I don't want to pay my debt, sir.
I understand that. I understand the nature of your motion, Mr. Cates. I know you're objecting to the motion. Do you think there's any leeway in the objection to the motion? I could adjourn for 30 days and have you talk to your client concerning this matter. I'm not placing you in an enviable position, Mr. Cates.
Yeah, no, that's not. Your Honor, I mean, as far, unfortunately, I mean, it comes down to the principles of commingling funds. I mean,
yes.
I mean, his name was on the account, and they didn't raise an objection that conforms to the court rules with objecting to the garnishment. So, I mean,
how did we
if
get
it is
here?
the court's prerogative to
if I didn't object,
you say no, you didn't.
Well, your motion doesn't appear, but I'll feel better. Well, I'll feel better about this. Mr. Sanders is pro per, and Mr. Cates, you see the conflict I have on some of this. I'm gonna adjourn this for 30 days. This motion, so the parties can contact. But Mr. Sanders, you are not in an enviable position at this time because you've given the court nothing to work with, only that this is your father's money, but your name is on the account. So you're responsible for any money in the account. That's the problem. I'm really doing this. I'm adjourning this to see if there's any wiggle room for negotiations here. But you are not in a positive position, Mr. Sanders.
Not considering myself being in one, sir.
I understand that. Mr. Cates, I'm going to extend this 30 days, this motion for 30 days. You can get back with your client and then be in contact with Mr. Sanders. If this is not resolved in 30 days, we'll set a control date for the motion, and I'll hear the specifics concerning the motion on that date. That would be available via Zoom, but we'll set a motion. We'll adjourn.
So you're saying there's no need to show proof that it was Earl Sanders' money that they took?
Ma'am, right now, there is no Earl Sanders money. Okay, there's only Keenan Sanders money. And he placed his name on an account. If there's some wiggle room concerning enterprise leasing and what they're willing to work with you, that's another thing. But under this motion, you can't commingle funds this way. Mr. Sanders wasn't in control of the account, which puts him in control of the money, which means that any of his debts are now the
But it was to
account's
take care of
debts.
his father, not himself. If you pay attention to the statement.
That unless he lied on the form, unless he lied to Comerica Bank, we got a problem.
What you mean lie? As far as just putting his name on it and take care of his father?
You fill out a form when you open an account and you put your name on it. You fill out a
open an
form.
account, sir. I was added on to the account. That was my dad's account, not mine.
Right, I understand. Your name's on your dad's account.
No, it's not now, sir. No, it's not.
You're not, I'm not talking about now. I'm talking about when you put your name on the account, which you've already verified that you did on the record here.
You did.
So, yeah, so I would, if Mr. Sanders, if I was you, I'd be negotiating with Enterprise Leasing because you've got about 30 days to see if you can figure this out. If you can't, we're going to come back on the motion. All right, so I've set plaintiff is in possession and it's plaintiff's motion. We're adjourning to a new date for motion, which will be 30 days out. So set it for October 9th at 1:30. In order to hear this motion, once again, and you have any of the paperwork concerning the debt to Enterprise Leasing, is that correct, Mr. Sanders?
Yeah, I have it.
All right, that probably would be the first phone call that you should make is to Enterprise to see if they'll negotiate with you in any way.
I don't think they have
anything
any
else for the
information
record
on there.
What's that?
I don't think they have no phone number or anything. Right. I
should-
guess, is it
what's a good-
586-868-2737, sir?
Yes. Is that, Mr. King, is that the good contact number?
Yes.
All right. That would be the contact number. So we'll be adjourned for 30 days. Thank you, buddy. Do you have any questions of me from Mr. Cates?
No, Your Honor. Thank you.
All right. Mr. Sanders, do you have any questions of me concerning this motion? I've adjourned it for 30 days in order for you to contact Enterprise Leasing to see if they'll negotiate with you.
And it's October 9th at 1:30?
October 9th at 1:30. Yes, ma'am.
Okay, thank you.
Thank you. You're all set. Thank you for your appearance today.
Yeah, have a
Thank
blessed
you,
day.
Your Honor.
You too.
So it don't matter if it was his pencil.
I think we have is Mr. Smith back? Or he's probably in the. So are we ready on Hall?
I don't know where Mr. Need went for Potts. Mr. Potts is here. I don't know if Ms. Lee is on Zoom, his attorney.
Here's in person. He's going down to Judge Bonnie's and Ward's court.
Oh, okay. Wait, who went? The attorney?
The attorney went to Judge Ward's courtroom. We're waiting on a need for Mr. Hall.
Yeah, Delamarter has not appeared, so.
Is that a public defender case?
I don't believe so. I don't have an appearance.
All right, let's call Delamarter's case.
Oh, wait.
Yeah.
I do have an
All right.
appearance. Let me double check. Yeah, it looks like
Is that a Mr. Ned case?
Mr.
also?
Ned, yeah.
All right, we'll do those two. Who is the attorney on Fox?
Ms. Lee is who is on the appearance, and I think our office has had contact.
All right, that's just so. And Mr. Smith, that's the one. So we've made sure that everybody is elsewhere. I think we might have to call again because that screen's not. I do that all the time. We ready on Hall?
I believe so.
Thanks. All right, so we're on the record in docket 2403-648, 2403-649, and accompanying ticket of 23L296963. Got two speeding.
I think the ticket may have defaulted, Your Honor.
Yeah, I don't know why I have these.
I don't know why you have them either.
They're both in default. All right, so we're on the record in those two files, 2403-648 and 2403-649. City of Lansing versus Derek Hall. Appearances for the record, Mr. Staples.
Matt Staples on behalf of the City of Lansing.
Mr. Ned.
George and then APD on behalf of my client, St. John, all right?
And sir, you are Derek Dwayne Hall, is that correct?
Yes, sir.
All right, thank you. This is the time set for a final pretrial in the matter. Mr. Staples, how are we proceeding?
Your Honor, the city has offered Mr. Hall to plead guilty to the reckless driving, and the city would dismiss the DWLS. I believe Mr. Hall is going to be taking that offer, but we'll be pleading no contest as to the reckless driving. I'm not sure what the basis for that is, but I'll leave that to Mr. Need.
Okay, Mr. Need.
Civil liability, Your Honor. I mean, there's the potential that something could happen that night. And with the police report, anybody could reach out and potentially have a lawsuit against them. I believe it's a reasonable basis, Your Honor.
All right, so it's a plead as charged on the reckless. It's no contest. And then it is a dismissal of the driving while license suspended. Is that a fair statement, Mr. Staples?
Yes, Your Honor.
All right, and what are we going to use as the factual basis for the reckless driving, Mr. Ned?
Your Honor, do you have the police report or do you have nothing?
I may have an affidavit. What's that?
I just sent a copy of the police report to Ms. Holden.
All right.
And Your Honor, I just want to apologize for the loud interruptions. Like I said earlier, I wasn't able to meet with them downstairs. Mr. Hall does have a loud voice, and we tried our best. So I apologize for any disturbances we caused.
No worries. As long as we can print out and then we'll use that as the no contest on the charge. Mr. Ned, may I, so it's a 1-for-1. The penalty for reckless driving would be a 93-day. Is that a 93-day?
Let me double check, Your Honor. Let me check the court's schedule as well.
Because it's written on a ticket.
93 days up to $500, 6 points.
All right, so Mr. You understand this is a misdemeanor punishable by 93 days and or $500, and up to 6 points may be abstracted. You understand that? All right.
Maybe.
Is that a yes?
It don't have to be, right?
It will be by the Secretary of State.
Okay, can
Yeah.
I ask you a question?
Sure.
Help.
Well, that's what your lawyer's for.
Confidence for something else.
No, your lawyer might be able to help you. but-
We talked about it, Your Honor. He's referring to some other stuff.
I just like to see you smile. Right?
Okay, well,
There we go.
yeah.
Okay.
All right. So I'm gonna, Mr. Ned, may I inquire of Mr. Hall of his advice of rights on his no contest plea?
Yes, Your Honor.
Okay. You understand you have the following trial rights, and I'm going to walk you through those. You have the right to be tried by a jury, to be presumed innocent until proven guilty. You have the prosecutor to prove beyond reasonable doubt that you are guilty, to have witnesses against you appear at trial, to question any witnesses that are brought against you. You are represented today by Attorney Georges Ned, and he would be present to cross-examine any witnesses or contest any charges brought against you by the City of Lansing. You have the right to court ordering witnesses appear in your defense, to remain silent during the trial, not to have that silence used against you, and to testify at trial if you choose to testify. If this no contest plea is accepted, you'll give up the claim the no contest plea was a result of any promises or threats other than what we've stated on the record from the city. You'll also be giving up the right to appeal anything from a trial, since you won't be having a trial. You'll be pleading no contest instead. Is it still your wish today to plead no contest?
Yes, sir.
Okay, thank you. All right. I'm gonna have you raise your right. I'm gonna have to swear you in for the no contest. And we are in agreement with the city, Mr. Staples, that I'm using the police report of 24/519-11855. That's Tyler Stover's report on December 11th. Is that correct?
That is correct, Your Honor.
Mr. Ned, that's what you provided that we published off,
Yeah, you said you're under 11855.
21-855. All right. So this is all for activity which occurred on December 11th, 2024 at Cesar Chavez on North High Street in the city of Lansing, Hingham County. It appears that the driver of the vehicle was observed disregarding the traffic control device. There was an acceleration of a high rate of speed, going about twice the legal limit. And then the police officer believed that the vehicle was fleeing. Mr. Hall was identified. You did not have a driver's license. So going to double the legal limit and continuing to flee would be the legal basis for the reckless driving. Is that a fair statement, Mr. Staples?
Yes, Your Honor.
Mr. Ned?
Yes, Your Honor.
I find that the factual basis being knowing, voluntarily, and accurately made concerning the no contest plea. So this is no contest to reckless. Mr. Staples, how did you want to proceed? Did you want this referred to probation?
I don't believe that's necessary, Your Honor. There was no accident, so there is no restitution. I believe immediate sentencing would be appropriate if the court so wishes.
All right, Mr. Ned, are you looking for do you have any objection to immediate sentencing in this matter?
Yes, Your Honor, Master Finance Counsel, but my client wants you to read these mitigation letters if that's okay.
Sure.
And approach.
They can be part of your allocution.
Okay, I'll just do that.
Okay.
I just read it out loud.
Yes.
Okay, Your Honor, my client wishes to. Want me to read it out loud? Okay. Your Honor, I'll be very brief. My name is Geronimo Lerma III. I'm the founder and executive director of Footprints, a Michigan nonprofit organization based in Lansing. Our mission is to provide new footwear to those who need it, most across the state of Michigan. I'm writing this letter on behalf of Mr. Derek Hall, known to many in our organization and community as D. McCain. I first met Derek in February 2021 when a mutual friend reached out seeking clothing and shoes on his behalf. From this very moment, Derek showed a genuine interest in our mission and the people we serve. He didn't just receive help, he chose to give it back. Derek started volunteering with us, cleaning and preparing shoes for distribution. It wasn't long before he came in daily, pouring his heart into work. It wasn't just about shoes for him, it was about dignity. It was about helping people feel seen, respected, and cared for. Through the service, I got to know the man behind the hardships, the man who had battled a difficult upbringing, faced the stress of Detroit, and paid the price with the time spent incarcerated. Through the countless conversations and mentorship, I watched Derek transform. I saw a man who wanted better, who fought daily to do better, to be better, not just for himself, but for everyone who crossed his path. He found his purpose with us traveling across Michigan, fitting shoes around seniors, families, and veterans. He became a familiar and welcome face in the veteran community, with his wide smile and genuine spirit making a lasting impression. Every year, veterans would ask him for him by name, eager to see the guy with the big heart. Derek's story isn't one of relapses or regrets, it's a story of redemption. He broke away from the environment that once held him down and chose a path of service and love. In 2023, he was honored with our Volunteer of the Year Award, voted unanimously by our board of directors, a small acknowledgement of the enormous difference he has made in the lives of others. I understand the seriousness of Derek's current charges, but I stand before you as someone who has walked with him through the highs and lows. I can tell you with full conviction, Derek Hall is a changed man. He is not the mistakes of this past. He is the kindness, the work, the compassion that he now lives out every single day. I respectfully ask that this court sees the man he is today with purpose, a man who has found his place in giving back to a world he once struggled against. He is proof that change is possible when someone believes in you and when you begin to believe in yourself. Thank you for your time. Geronimo Lerma III.
Mr. Staples, anything you'd like to say to the court before the court passes sentence? And I'm trying to figure out, do you have a credit for days? Because his bond was set as 1,010%.
Yeah,
and I don't know.
I don't know, Your Honor. As far as time served, I believe Mr. Hall may be facing additional issues as well, so I don't know if he has credit on this case or not.
No, you got the board when you incarcerated on this file. That's this one I got incarcerated first, the second.
I don't know.
It's on the 11th.
He said he gets on the 11th of October.
No, I get out on the 11th, but the original, the second bond, they gave me that bond initially, then they gave me another bond on 80, hold on, 70,
He's here, Honor, right? He's held someplace else.
to 11.
I think he's home down in
It's like
Macomb.
40
Yes,
some
that's
days.
correct.
A little bit over 40 some days.
So he's got 4 days on our files.
Did you want anything towards allocution from the city, Mr. Staples?
No, Your Honor.
Okay. Mr. Net, anything else on the allocution before I turn to Mr. Hall for any statement he wishes to make on judgment of sentence?
Hang on.
Mr. Hall, is there anything you'd like to say to the court before the court passes sentence? We were able to listen to Mr. Net's rendition of the letter that was written for you.
Well, all I can say is I apologize. It wouldn't happen again. I wish I could go back and change things. I can't. People make mistakes, and when you make mistakes, my thing, I got a real bad thing with the police, so I like PTSD or whatever you call it. I think that's what they say. But I'm getting better at dealing with people and my issues that I grew up with. So
you're read out of Macomb County to come here, right?
yes, sir.
Okay. So you've got other things going on.
Yes, sir.
All right. So we'll give it. So I'm going to sentence the defendant, Mr. Hall, to it's 7 + 4 because we got at least a week in there from last week, right?
Yeah, but they gave me a bond on 8/11.
They bonded you out on this one?
On this one, yeah. When I came back on 8, hold on, was it? No, before 8/11, hold on. First time I came back was what, 7? They gave me a bond that day. 7/29, they gave me a bond 7/29 because I had already had that $500 PR bond. So I was trying to wonder why they was giving me another bond.
I don't know.
They gave me another bond because
you were writ out.
It said 90. It says right here. It says 93 days. I got it.
Right.
It says when I started on. See, it's right. This is one paper on paperwork to get right. Okay. So it's
because we have a credit.
This is the bond right here. They gave me the bond.
I just want to make sure we get the last week.
That's the date. This day right here.
What's the date on that?
July 7th.
Told you.
So on July 7th, he was arraigned and given a 10% bond.
Bingo. That's
He
jail
would have
time.
PR'd on this in 4 days. And
It
that's
says
it.
jail time right there. It says
So we don't know that. We just know that that's the policy.
Ingham County would
That's the
have-
policy.
Ingham County Jail right there. How they supposed to
Yeah.
get bond?
Usually you're PR bonded from Ingham County after 4 days on a traffic offense.
I thought it was 7. That's 7 on other.
Yeah, but I was just making sure that we get the credit right.
Correct.
We're not going to order any additional jail with this. Okay.
I appreciate it.
I just want to make sure we get some.
Now, I'm in there to 10/11 anyway. I
Right.
got out 10/11, 4 a.m.
We'll do, I'm going to add on the 7 from last week. So 11 days. Okay. So 11 days in the Ingham County Jail. Credit for 11 days previously served. Now, you're gonna get the 6-point abstraction. That's automatic.
You just told me I can get my license for 2 years.
But yeah, it's gonna be a couple of years, at least a couple of years.
I'm gonna try to go back to Detroit and try to get those, cause I done a plea by mail. I did everything cause God told me to do plea by mails, and I did everything by plea by mail.
Yeah,
And
that's
shouldn't have plea by mail them. I should have went and then seen if the officer showed, cause they was all from like 2018, 2020. I haven't did nothing since 2020. I've been here and I've been clean. I've been working and I need my vehicle to do my construction work for real, but I gotta figure something out.
Okay, well, that 6 points is gonna be abstracted, so, 200 fine, $200 cost. Crime victims' rights fee is waived. And the state fee is waived. It'll be $400 to the city of Lansing, but you're not getting out anytime soon, I don't think. What's the date of?
October 11th.
October 11th?
You could just.
And
The collection.
Yeah, let's refer to collections.
Yeah, all these things just need to get removed.
yes.
Can I give them $10 a day for them?
No.
Yeah.
No.
Give me jail time.
So,
I don't want to pay.
well, we're gonna set it for $400, and then you can contact the city of Lansing. It'll be after October.
I don't have a job.
Right, I know, I understand. I understand
can't
that.
work if I can't drive.
But
No, I need
so-
to go to jail and do this.
So it's City of Lansing for $400. It'll be after October.
Go crazy. I
Um,
want to go to jail. I still do 92. I don't care. I want jail.
We're all set. I appreciate it.
all right, I placed that you won't be out of Macomb till after October 11th.
I can't pay. I got too many other bills. They still gonna try to pay me.
All right.
Those collection time. Oh, don't you see?
All right, so that's all the record in 2403-648 and 2403-649. Mr. Hall, good luck.
Pretty Tony, man, why you do me
Yeah.
like this? I love you, my baby. Have a good night.
These are referred to collections.
Yeah.
I like it, man. I understand.
Welcome to the other side.
Yeah, man. How's everything been?
Horrible.
Troy Cat, he's good people. He's good people. He don't care about the money.
I know, I like him.
He wants to see, I want to see Mr. Flores
I think we
smile.
have a failure to appear on Delamarter.
Mr.
that,
Delamarter?
Mr. Anita's on, and then we
Am I?
can, I have an appearance
Uh-oh.
for you.
I guess I'm on it now.
Is that, so Delamarter and Potts?
Yep, the attorney's here for Potts, but if we do Delamarter, we can send Mr. Anita on his way.
All right.
that's fine.
All right, so we're on the record in docket. Oh, Mr. Smith. We're on the record in docket 25-01605. That is people of the state of Michigan versus people of the city of Lansing versus Mark Delamarter. Appearances for the record, Mr. Staples.
Matt Staples on behalf of the city of Lansing.
Mr. Ned.
George and Ned, this is APD on behalf of Mr. Mark Lewis Delamater, who is not here today.
All right, this is set for pre-trial. We've had some conversations about Mr. Delamarter. We weren't sure who was representing him. It appears that a appearance has been filed by the public defender's office. This was set for 10 o'clock. It is now 11:37. And it would appear that Mark Delamarter has failed to appear today for the pretrial. I do not see Mr. Delamarter in the Zoom courtroom. Mr. Delamarter is not in the physical courtroom, and nobody has answered by that name in the hallway. Mr. Annette, have you had any contact with Mr. Delamarter?
No, Your Honor, I do see in my file that we had a pretrial on the 11th of this month. I was not here for that. Was that held?
It looks like it was a fail to appear on the 11th.
Oh, so he must have got picked up in between then and now.
Yeah, and then he was set for on August 14th. We set it for today's date.
Okay.
And so.
Yeah, no contact, Your Honor.
Yeah, so Mr. Staples, it appears the defendant failed to appear for the pretrial today. There is a previous fail to appear in which we placed a 48-hour hold. How would you like to proceed?
Your Honor, the city would ask for an immediate bench warrant given the prior failure to appear.
Right, because of the prior failure to appear, and I think this is more than one that Mr. Delamarter's failed to appear. I'll issue an immediate bench warrant for the fail to appear for the pretrial. Anything else for the record in 2501-605, Mr. Staples?
No, Your Honor.
Mr. Net, you should be all set. Then we'll go on Mr. Potts.
I know the other attorney from our office has been talking to your office, so I would rather just let them continue having this conversation. Sure. I'm just filling in for today. This was originally my docket, and then she's taken over, so. No, she probably did. Sure, but we'll just reset it to let those, yeah.
So you just want to reset the.
I think it'll have to be set for trial at this point, but we can put that on the record.
And I don't think our trial date's till October right now.
Yeah, and we'll have to do, as I was telling him, we'll have to set it a bit later than that because the officer is having surgery today, so.
Okay.
What is the officer set has a conflict on that date?
Yeah, it would need to be mid-November.
That's fine.
Because he's gonna be out at least
I don't know
a month plus.
I don't know that we
How about this? How about let's set it for an additional pretrial?
That's
and then we can get the jury trial date.
Sure.
That'll build some time in.
Your Honor, I would just ask if I may, can we do it in the morning? He just works at 2:30. He's been here a couple times. Okay, if we do it in the morning?
Absolutely, not a problem.
Yeah, GM's kind of strict about that. So.
You are not the first person to make that request.
Yeah.
Let's do an adjourned pretrial since the officer is in surgery, and we'd have to move this out to November. And I don't know if you want to wait that long.
No, I prefer not to. Because
Okay.
again, this is a case too. You have to get into the facts.
All right.
Where it was the officer isn't the witness. There's other witnesses.
Let's set this. We'll set, and I know it's Miss Crock-Mollay's docket now. Is that right? Correct, Ms.
Correct, Your Honor.
I only know that because I have a hard time pronouncing her name.
I wouldn't have even went for it if I were you.
Yeah, it's hard work. So 30 days out?
Okay. Do you want a final pretrial or a pretrial?
Just a pretrial, just a regular pretrial.
Well, Your Honor, if I may, is there any way we can do a file
Yes.
Well, with witnesses forced to appear, because this is a reckless driving, where the officer was informed after the fact.
Okay.
And so there would be witnesses that need.
All right. All right.
And again, also, if there is a resolution prior to that, and I completely understand brother counsel's point where this is another prosecutor's docket, no one wants to step on anyone's toes. If it is resolved, we can inform the court to take it off to clear up your docket, because I know you're busy.
Yeah, we can set it for plea or whatever. All right.
Perfect.
So let's adjourn for final pretrial. The witnesses will be subpoenaed and we'll set it for 30 day, in the 30-day range.
And he needs a morning.
Morning.
Well, before 2:30, yeah.
Yeah, before 2:30. I think morning would be easier.
Okay, are we gonna call it to the record or?
Yes.
Okay, we'll do September 22nd at 9.
Does that work for your schedule?
I'll make it work, Your Honor. For him, I will.
All right, let's go ahead and call 2501-481 and 2501-482. It's the City of Lansing versus Austin Potts. Appearances for the record, Mr. Staples.
Matt Staples for the City of Lansing.
And good morning, Your Honor, to you and your staff attorney, Maxwell Dubin, P number 86012, on behalf of Mr. Potts. Mr. Potts, as you know, I am filling in. Do I have your permission to fill in for you today?
And it's Dubin, D-U-B-I-N?
Yes, sir. Yes, Your Honor.
And sir, you are Austin Potts.
Yes, sir.
All right, thank you. This time set for a final pretrial in the matter. We've extended to adjourn to another final pretrial with witnesses available, would be subpoenaed for that date for, it's my understanding, for September 22nd at 9 o'clock.
And for the record, that's also my understanding.
Perfect. Perfect. All right, so we've set it for pretrial on September 22nd at 9 o'clock. For further pretrial, that'll give us the opportunity to build some time in Anything else for the record in this file 481 or 482, Mr. Staples?
No, Your Honor.
Mr. Dubin?
No, I hope you have a good rest of your day and good to see you guys.
Thank you. You're all set, Mr. Potts. We'll see you.
Sure.
The witness would call the cops.
I think there was, the officer did have some observation on it based on my last note, but that's,
I
they can check that
Yeah,
out.
yeah. Okay, cool. Good to see you, man.
So-
Sorry I was late, Your Honor.
You're all right.
I
You're all right.
pulled over, those implied consents, you can't be like 1 minute late, but the officer can appear like 20 minutes late. I pulled over at a gas station on the side of the road, I'm like, oh, God, I'm trying to pull over. Thank you.
You're welcome.
I mean, I'm one of
Where
the-
did Miss,
You have my number. You always make that.
I think we're all set, Mr.
Thank you, Your Honor.
Staples.
Have a good
You're
day.
all set. All right, let's go on Mr. Van Moeller.
No, I put it in my calendar. Don't go to bed.
So we're back on the record in docket 1302023. That's Lansing Automakers versus Tyler Van Oler. Mr. Smith, were you able to speak with Mr. Van Oler in a breakout room, or what, if anything, came out of that meeting?
We weren't able to complete the Q&A, Your Honor. Mr. Van Oler was not providing answers to the questions. We get to a point where after telling me he was unemployed, then with some further digging, he at least admitted he does scrapping. He does scrapping with a friend. They dropped the scrap off at Pad Nose. He said that, at least his testimony was, the account's not in his name, it's in his friend's name. And so after the two of them go scrap, the friend gets the cash and then pays him. So we have someone who is paying him income for services performed. I said, well, what is the name of this individual? Mr. Van Oler refused to give me the name. So we halted the exam at that point, seeking some direction from the court, or at least I can't complete the exam until I get name, address, all the information I need regarding folks that are paying him to perform services, which would clearly be the guy he's scrapping with.
Mr. Van Oler, is that a fair statement?
Yep.
All right, Mr. Van Oler, my only recourse is to have you appear in person and then provide that information per the discovery request. If you don't appear in person, we'll just show cause you. That's my understanding, Mr. Smith.
Can
Right,
me
Your
and Smith go to a breakout room and try to work something out if he's willing to?
I'm not sure what you just said because you were breaking up, Mr. Van Oler.
Me and Smith. Oops, sorry.
Yeah, did Mr. Smith, did you want to give it another shot in a breakout room to discuss this matter?
I'm willing to talk to him, but if we hit another dead end, we're gonna have no choice but to just set it for an in-person hearing.
All right. So Mr. Van Oler, yes, the answer is yes to your question. Mr. Smith will talk to you in a breakout room. But if there are any more bumps in the road, and we come back here, we'll just set it for a show cause hearing. All right, sir?
Alrighty.
All right. I'm going to indicate all parties appear to meet in a breakout room. And I'm going to send you, I got to build the rooms now a little bit. All right, so Mr. Van Oler, you'll get a prompt to go to room 2. And then Mr. Smith, I'll put you in room 2. Mr. Van Oler went back to room 1. Okay, you're in room 2, and then we can come back and put it on the record if it's unsuccessful.
You bet.
All right. All right, Mr. Smith, were you able to conduct a discovery hearing?
Yeah, can we pull Mr. Van Oler back in? And I'll let you know how we wrap this up.
All right. I'm going to go ahead and, because we're having the same problem, I can't. I'm going to close all the breakout rooms. And then, Mr. Smith, we have the other breakout room with the interpreter and Campos. And we'll go ahead and throw you in that room after we get Mr. Van Olers on the record.
That sounds good.
Interlocutorio con la capital, sí. En la capital, no en Oriente.
All right, so we're back on the record in 1302023. That is Lansing Automakers versus Tyler Van Oler. And Mr. Smith, you were able to meet with Mr. Van Oler in a breakout room. How are we proceeding today?
Mr. Van Oler and I met in the breakout room. We've structured a payment plan that should take care of the balance remaining here. He's going to pay $1,500 payable within 14 days of today's date. Then beginning September 22nd, we'll commence payments at $250 a month until paid in full. I'm going to get in writing to him, reminding him as to the arrangement that we have structured and where to send those same payments. If I also explain to Mr. Van Oler, if he misses one payment, we will refile a motion to show cause. We will be back in here to complete this examination because at this point, he doesn't want to produce the information, and I'm fine with him not producing it as long as we get paid and get this taken care of.
All right. And Mr. Van Oler, did Mr. Smith say anything on the record that was not a part of your agreement?
No.
All right. You understand you have 3 days from today's date to indicate that what we did here, I don't know if that applies to civil cases. Does that apply to civil cases, Mr.?
Okay. It does not, Your Honor.
All right. All right. Thank you. All right. So, Mr. Van Oler, that term's been placed on the record. The orders to follow for the court to sign. Anything else for the record in 1302023? Mr. Smith.
Nothing for plaintiff, Your Honor. Thank you.
All right, Mr. Van Oler, you should be all set. Thank you for your appearance today.
You can go,
Thank you. All righty.
All right, and then Mr. Smith. So, I'm going to place you in a breakout room with Mr. Campos because they're on an iPad, and then we'll come back and put it on the record.
Thank you, Judge. I'll make it quick.
All right, so we're back on the record in 1601363. That is LAFCU versus Roberto Campos. And Mr. Smith, did you have the opportunity to speak with Mr. Campos in a breakout room?
I did, Your Honor, and Madam Interpreter was very helpful. Mr. Galvez Campos did produce ahead of time all the documents ordered by the court. We've reviewed those documents. He's in complete compliance with the production. We completed the Q&A part of the exam, and at this point, we can consider the examination to have been concluded.
All right, and is that a fair statement, Mr. Campos? You provided all the paperwork to Mr. Smith, the discovery hearing was held. Is that a yes? Okay. All right, the next, so this will be set by the civil department, won't it?
There's no need for any type of follow-up or control date. We've completed. Yeah.
All right, perfect. Anything else for the record in 1601363, Mr. Smith?
Nothing other than Judge Stevens this morning up in Clinton wanted me to send his regards.
I'm a big fan of Judge Stevens, so.
He's a good guy.
He is a good guy. Mr. Campos, do you have any questions of me?
No.
You should be all set, sir. Thank you for your appearance. Thank you for your assistance today, man. You're all set, Mr. Smith.
Thank you, Judge.
This has very little to do about electrical outlets. This is a